Yeah, we just share it. I mean, that's what we've done before. Is just slide it over. It picks up pretty well. Just slide it over one way or the other.
Tony, when are you actually taking off?
Tomorrow morning at 8:30.
Ooh, the flight's at 8:30? Ooh, that's not pretty.
So I have a meeting at 3:30. Because I'm on the nominating committee now for the section. So we meet from 12 till 2:30.
Yeah. Chicago? Yeah, it'd be reasonable. I mean, that's a little tight, because O'Hare can be a pain in the ass.
I'm supposed to be there at 9:18.
Yeah, with the time
So,
change. Yeah.
I'm just going to take public transportation.
Yeah. Yes. Yeah. I mean, I don't know how often you've done getting into the city of Chicago, but I
This will be
never
the second time I've been.
ever. Oh, yeah. You went there last year for the first time. I never drive from the airport to the Loop ever. The Blue Line works quite well.
Great. Well, I think we can go ahead and get started. I wanted to, first of all, welcome everybody to our annual Constitution Day event. We do this every year on Constitution Day. Obviously, it's an important day and an important event, and our nation's founding document, and obviously something that we pay a great deal of attention to. But it's a particularly special, I think, Constitution Day because of the prominence of our speaker or one of our panelists, and we certainly do appreciate the time of all of our panelists, but especially Evan, who had to come in from out of town to come and speak with us. So welcome, Evan, as well as welcome all of you. We're delighted to have everyone here for this event. I will just give you a general idea of how this program is intended to work. I guess I should have said, I am Haider Hamoudi, the Research Dean at the University of Pittsburgh School of Law. So, but the way that the program will work is that there will be about an hour of substantive discussion, largely with the Dean moderating and asking questions to both Evan Wolfson and our own Tony Infanti. We'll also see a short video in the context of that, and that will last for about an hour. We then want to give an opportunity to Representative Dan Frankel to speak a little bit about the Pennsylvania Fairness Act, which has to do with implementing anti-discrimination measures in the, enacting anti-discrimination measures in the Commonwealth of Pennsylvania that would prohibit discrimination in employment and housing and other places against members of the LGBT community. Some of you may be surprised to hear that in the Commonwealth of Pennsylvania it is perfectly legal to fire someone or deny them housing on account of their gender identity or sexual orientation. But he will talk about his longstanding efforts to address that. And then after that, we will have audience questions and answers. The way that we'd like to do that is via note cards. There will be note cards. They aren't there now, but you can imagine them. Just up there on the podium along with some pens. Just go ahead and write your questions down. And then I think just bring them to me. I'll be sitting up here on the front right, and front left, excuse me. And then I will make sure to get them to the Dean in time to ask the questions. So before we do anything else, and before I sit down and finish my least interesting part of the evening, I did want to make sure to introduce the speakers. As I mentioned before, Evan Wolfson, the founder and president of Freedom to Marry, and has been really the driving force behind the marriage equality movement in the United States. In 2004, Time named him one of the 100 most influential people in the world. 2012, he won the Barnard Medal for Distinction alongside President Obama. Prior to founding Freedom to Marry, Evan launched the marriage movement as a legal matter in the state of Hawaii in a famous 1990 Bear case. I believe it started in 1990, unless I'm mistaken. That case ended with Hawaii amending its constitution so as to prohibit the very possibility of same-sex marriage, and Congress, not quite happy with that result, decided to enact another statute to confirm that there could never be same-sex marriage, known as the Defense of Marriage Act, or DOMA. So it gives you a good indication of how long the struggle has gone on and how deep and influential Evan has been in it, both in litigating these cases and fighting these sorts of legislative reactions. He's also argued before the Supreme Court in the Boy Scouts of America versus Dale case. He's taught at Columbia as an adjunct professor, as a graduate of Harvard Law School, and has taught political philosophy at Harvard College. So obviously a stellar resume. I don't know exactly what else you could possibly add to this, but I'll let him build on his resume in years to come. Secondly is our own Dean, Dean Carter, who's the Dean of the University of Pittsburgh School of Law. His modesty made this a little bit more difficult because he just has on his bio, "I'm the Dean," but he is a former professor at Case Western at Temple, and also one of the leading scholars of 13th Amendment jurisprudence. So literally one of the top 5. There's only about 3 or 4 people that I think anyone would ever go to try to understand the 13th Amendment, and our dean is certainly one of those leading voices. Professor Infanti, Tony Infanti, has written, is a very prominent tax professor, has written on the intersection of tax and comparative legal theory, but also critical tax theory, which has to do with the impact of the tax system on disadvantaged groups. The focus of the disadvantaged group that he focuses on the most, not exclusively, is on LGBT couples, and has written in a number of prominent law reviews. Just published a book, edited book about this, about critical tax theory. And again, and I say this without exaggeration, one of the leading voices in critical tax theory in the academy. So we're delighted to have. I should also say he's a phenomenal teacher. He has won not only the Chancellor's Distinguished Award for Teaching, but also the award that the students give every year for excellence in teaching. So we're delighted to have 2 such prominent members of the faculty among us. I do want to make sure that I don't forget Representative Frankel. Since 1998, I believe he has served in the Pennsylvania legislature, and has been an outspoken advocate for civil rights and public health generally, and has championed legislation year in and year out of the type of like the Pennsylvania Fairness Act to try to bring equality to Pennsylvania for LGBT residents. That obviously is not the only thing that he's done. He's also opposed efforts that have been designed to limit women's health care options, and has been a very active legislator and a true leader in civil rights, working within the legislature to do that. So without further ado, I'm going to turn the podium over, turn the matter over to the dean, but I do want to make sure that we offer all of our speakers a warm welcome.
Thank you, Dean Hammoudi. Thank you all for being here. I hope you all can hear me okay. As you can probably tell, I'm struggling with a little bit of a cold, but that's okay because I'm not the feature attraction. I am just here to open a conversation and prompt some dialogue around some questions that I've come up with for Evan and Tony. And I will launch right into that in a moment after I just make a couple of notes. First off, I want to thank Tony for taking the time to do this. As you'll see, he has a great range of expertise and wonderful insights on these topics. But I also wanted to tell Evan publicly just how delighted I am to meet you in person and honored to have you here. I've followed your career and work, I think, since I've been in law school, and have always known who you are and the important work that you do. Didn't know until fairly recently that you're a native son of Pittsburgh. So when the opportunity arose to have you come home, it was really a treat to be able to do so. And I also wanted to mention, if I could just take a moment, that I think the topic is important, and as you'll see, the insights that you'll gain from the conversation are ones that are really critical. But when I think as a dean and a teacher, it's not just the substantive topics that make these kind of events so special, and it's not just the prominence and prestige of the people we bring here to talk about them, but thinking as an educator whose job it is to train future lawyers. Having the opportunity to have such a prominent and driven and committed and diligent civil rights advocate come here as a model for our students is really probably the highest impact thing that I hope will come out of this. In a lot of ways, you're what we want to be when we grow up, and I include myself in that category. So I do hope that during the reception you'll have a few moments to spend some time with our students, dialoguing with them, and really encouraging them to understand that, you know, the life of the common law are the lawyers who make it, and that they can do what you've done, and I hope that they all will. So with those words of introduction, I do want to start the conversation so that you're aware of the format. It is going to be less of a lecture format and more of a dialogue where I'll pose questions to each of our panelists, and then, as Hyder said, we'll then turn it to the audience for questions toward the end. So I wanted to start with Evan, and I wanted to start where most stories start, which is at the beginning. And I was hoping that you could illuminate for us a little bit about your journey. As I mentioned, you are from Pittsburgh. But what motivated you to get into the law, and what motivated you to choose this path for shaping your interest in the law around this issue?
Well, first, let me thank you, Dean, and your team, and Tony, who I've shared the stage with before, for bringing me back home to Pittsburgh. It's always good to be here. I always can count on my family and my friends to be here to pack the audience in case there's ugly questions. And it is very always moving to be back in Pittsburgh and to be able to be part of the community, even as I have been working in many communities. And it is also really moving to me to be invited to participate in Constitution Day opportunities to speak, because the Constitution is something very precious to us, and it gets pushed around a lot, particularly during political season, by politicians who play with fire near something very, very precious. But it is important that we remind people how lucky we are as Americans that we have the Constitution, that it gives us the safeguards and the protections and the opportunity to work on what we commit ourselves to as the American people, building a more perfect union. So I'm really honored that you invited me back and have me as part of this good dialogue. So when I grew up in Pittsburgh, going to high school here, elementary school, high school, I was the kind of kid that everybody said, oh, you really love to argue, you should be a lawyer. So it always was sort of given to me that I was going to go to law school and be a lawyer, and what motivated me to want to do that, in addition to that love of arguing, was that I really always found my great passion in history and in politics and in the idea of making a difference. And I saw law very naturally as part of what one did in order to get into government and into making a difference. Of course, one of the things I learned on my journey as a law student was there are many ways you can use the law. In many ways you can use the law degree and the training. And it doesn't always have to be in litigation or in a law firm or in government that one can use the skills and the cachet of being a lawyer to make a difference. So that's what really kind of put me on the path. And as I did the legal studies and wrote on what I wrote on, which I assume we'll talk about, it really connected my great passion for history, which was always there even as a kid, to my own personal journey as a gay man and as somebody who saw injustices, obviously not only for gay people, but for gay people, to my desire to make a difference. And that all came together in my decision to go to law school, in my experience as a law student, in what I chose to do with my law degree, and then in what came out of it. And really the final part of the story, and then we can flesh it out, is that one of the things I really discovered as a law student, which wasn't a new discovery, but was new to me, was that while law and litigation and engagement as a lawyer are very, very important parts of social change, they're not sufficient. And so even thinking as a lawyer and even thinking about how you use the law, you need to think outside, quote unquote, the law. You need to think about the culture. You need to think about persuasion. You need to think about hearts and minds. You need to think about politics. You need to think about the political tools and the machinery you need to build. And those insights that came to me, even as a law student in law school, really grew as I then began doing my legal work once I graduated from law school, and certainly became the centerpiece of my, so far, life's work in shaping the campaign to win marriage and to change the law, using law as a tool, but not limiting the work to the law.
Sure. So let me pose a follow-up question to you, Evan, in that regard. Take us back when you first started engaging in this work, you know, and I know you did many things before Freedom to Marry, but we do have a short video clip about Freedom to Marry itself. But, you know, it's hard to know how you ended up where you are unless you understand where you've been, right? So let's talk a little bit about those kind of cultural, political factors, kind of when you first started engaging in this work in the 80s, really? Is that fair to say?
Yeah.
What was the tone back then? What was the politics? What was the rhetoric? What were the policies? Where did we start on this arc?
Right. So I graduated law school in 1983, and it was a terrible time for gay people. It came after the first big flourishing of the gay rights movement and its claiming of a civil rights space and the political organizing that we often think of as dated around 1969 and Stonewall and the 70s and the progress that was made, but also the terrific onslaught and attacks that gay people dealt with on the political side, people like Jerry Falwell and Anita Bryant, and rolling back the legal and political gains that gay people had begun eking out in an organized fashion in the 70s. And then in the 80s came the most hostile to that point political administration that gay people ever had, the Reagan administration, which essentially declared war on gay people and gay rights as they did on a number of other civil rights frontiers. And in the midst of all of that came AIDS and this cataclysm of life and death and destruction. And gay people would literally be walking down the street in a war zone of our own lives with our friends dying and horrible sickness and fear and threats in a world where many non-gay people were completely oblivious to it, and you would just have this completely surreal, dissonant life. And so it was in that period that I was a law student and had come back from the Peace Corps, confident in my own identity as a gay person and trying to decide now what that would mean in building a life. And into that, I came to law school and came into this political environment. And so in that political environment, I was very committed, and I can go into it more if you want, for how I got to this path, but to writing and then to doing pro bono work and to choosing political and legal work that would enable us to change this injustice that gay people face. And one of the things I did in that period was write my law school thesis on how we would make that change. And the nutshell answer was we would change it by claiming the freedom to marry, and that the freedom to marry would, A, bring us into a legal and political institution that was essential to full equality and dignity, and it would also allow us to claim a vocabulary of transformation, a vocabulary of persuasion, of understanding that would help non-gay people better understand who gay people are in a way that would then allow us not only to win marriage, but would allow us to change the position of gay people in society. And so that was the period in which I was writing, and the progress that had been made, and then the horrible attack and onslaught and death and fear that we were coping with even as we were regrouping and figuring out how to move forward politically and legally in the 80s.
Sure. So I want to talk a little bit later about the intellectual foundations because they're both interesting and to some extent contested, both within and without the LGBTQ community. So I want to talk about that in a bit. But I did want to ask now if we could play the brief video that kind of gives some history of the arc of Freedom to Marry's work and then return to the conversation with a question for Associate Dean Infanti. And at some point, someone's going to lower the lights so you can actually see it.
While we're doing that, let me just say that this is the video that Freedom to Marry commissioned with a Pittsburgh filmmaker who actually made it, Eddie Rosenstein. that we played on July 9th at the victory celebration that we hosted in New York to celebrate the win and to mark Freedom to Marry's closing down.
We have come a long, long way. And today we celebrate a transformation and a triumph. The freedom to marry nationwide.
Progress on this journey often comes in small increments. Sometimes 2 steps forward, 1 step back, propelled by the persistent effort of dedicated citizens. And then sometimes there are days like this, when that slow, steady effort is rewarded with justice that arrives like a thunderbolt.
Within living memory, gay people in America were a despised and oppressed minority. Our love was scorned, not respected.
NBC News found that a majority felt that homosexuality was immoral.
When our loved ones were sick and even dying, our own government could barely care less. Early pioneers had bravely stepped forward to claim the freedom to marry. The country wasn't ready. Their dreams were laughed at, their cases dismissed.
Officials turned him down flat. A marital relationship cannot exist between faggots.
But at the heart of discrimination against gay people was the denial of our love. For our dignity, our equality, our families, we had to fight to see our love respected. We had to claim the freedom to marry.
Even writing my paper in 1983, I believed that our fight for the freedom to marry would be an engine of transformation.
There was resistance and uncertainty, even from within the movement.
A lot of people say that civil unions are the same as civil marriage, but they're absolutely different.
So gay people continued to dream of being able to marry the person they loved. Then, in Hawaii, a tectonic shift.
A Honolulu judge told Hawaii state government it cannot deny a marriage license to gay couples.
Many, many couples stand on the brink of being able to do what every other American takes for granted, exercise the freedom to marry.
But what we won was stripped away in a political attack.
The president signed a bill barring federal recognition of homosexual marriages.
Winning in court was not enough. We needed to build a true campaign that could drive our strategy. We needed to be able to win and defend our wins. We needed to move the country to win nationwide in the Supreme Court. And we did. Along the way, there were painful losses.
Marriage is the most fundamental institution of civilization.
52% of voters supported Proposition 8 to ban gay marriage.
The fact that some people would like to undo our I do makes me very sad.
But we never gave up. We learned, we grew, and we won in court.
By the power vested in me,
I now pronounce you
Legally married.
We gave Americans a chance to see families helped and no one hurt.
These couples will finally be treated equally and fairly by their government.
They said we couldn't defend our win, but we stuck it out, and we did.
Today, Massachusetts lawmakers voted to uphold gay marriage.
They said we'd never win in the heartland.
Iowa became the third state to allow same-sex marriage.
They said we'd never get the people behind us.
For the first time, a majority of people support gay marriage.
They said we'd never get Republicans to join Democrats and independents on our side.
No, freedom means freedom for everyone.
And they said we'd never get elected officials, a vice president, and the president to come on board.
I think same-sex couples should be able to get married.
Some people said we would never, ever win at the ballot, but we learned how to do it. And in 2012, we won 4 out of 4.
We have finally won.
We convinced the nation that love is love.
People learned that we were their kids and their cousins and their friends. We were human beings like everybody else.
This was our journey. Together, with a movement of many, a shared strategy we stuck to, a campaign to drive that strategy and spearhead that movement. We learned. We built. We rebounded. We kept going.
This morning, the Supreme Court recognized that the Constitution guarantees marriage equality. That's the consequence of the countless small acts of courage of millions of people across decades who stood up, who came out, willing to endure bullying and taunts, and stayed strong, and came to believe in themselves and who they were, and slowly made an entire country realize that love is love. What an extraordinary achievement. What a vindication of the belief that ordinary people can do extraordinary things. Those countless, often anonymous heroes, they deserve our thanks. They should be very proud. America should be very proud.
Love won. We all won.
Thanks for that. That was well done. As the lights are coming back up, I wanted to start transitioning the conversation with a few questions for Tony. The video covered some of this ground in terms of kind of the politics and the steps that occurred at the state legislative level. But I'm wondering if you could give us kind of a brief helicopter tour of the law in this space, whether it is at the constitutional level with the Supreme Court cases over the decades culminating in Obergefell, or at the state policy level. What was the trend line that we saw? How would you describe the evolution of this body of law?
I would say it was, it started out slow and then it became much quicker. Sorry, I have a little bit of allergies. And so, as you saw some from the video already, and as Evan mentioned, this battle goes back quite a long time. The first cases were actually in the 70s, the early 70s, right after Stonewall, were the first cases where people were trying to get same-sex marriage and were pretty quickly denied. And so there was some movement then, and then in the 80s, things were, as Evan said, very, very hostile. You think of, Bowers v. Hardwick being decided the year I graduated from high school. So that's what I grew up into, was, seeing a country where it was very, very hostile to be gay. And then you move into the 90s, and that's when things started to change a little bit more. That's when you had the litigation in Hawaii. And in 1993, when I graduated from law school, was when the decision came down in the Hawaii case. And then that made it seemed like things were going to change very quickly, and basically the way they've been changing quickly very recently. And I think a lot of people thought that is what was going to happen then, and it's not what ended up happening at all. You see within a couple of years after that, the Congress, as Professor Hammoudi mentioned, Congress passed the Defense of Marriage Act, basically denying recognition to same-sex marriage at the federal level and sanctioning the states denying same-sex marriage any kind of legal recognition. And then you just saw, kind of more and more states adding statutes and then constitutional amendments on top of statutes banning same-sex marriage. And you didn't really start to actually see movement towards marriage until the late 90s, when you see Vermont get civil unions in 1999. And then the first state to get same-sex marriage wasn't until Massachusetts in, was it 2003, really 2004, was when they started marrying. And that was right around the same time as Lawrence v. Texas was decided, when the Supreme Court reversed Bowers v. Hardwick. And you see some slow movement, some states getting, civil unions or domestic partnerships. You have marriage in Massachusetts and then later marriage in Iowa, and sort of slow progress, things moving slowly. Things didn't really start moving until you actually had the litigation at the federal level. When they challenged the portion of the Defense of Marriage Act that prohibited the recognition of same-sex relationships at the federal level. That was the Windsor case that was decided basically 2 years ago, 2 years to the day that the Obergefell case was decided. And that in that case, the Supreme Court decided that, they were going to strike down the Defense of Marriage Act on constitutional grounds, the portion that applied to federal law. And then that's really what gave the impetus. Then you saw just almost a torrent of decisions from lower federal courts in different states striking down one state marriage ban after another, with very little exception, until you actually get to the Obergefell decision earlier this year when the Supreme Court just got rid of the last of them.
Thanks, Tony. In a slight tangent, I want to reach a consensus on how we pronounce the name of the Supreme Court case that we're about to discuss. Tony?
Well, I said I have no idea how they actually say their name.
Evan?
It's Obergefell.
Obergefell. Thank you. Okay. So I wanted to transition to some discussion of that case in a moment, but Evan, I wanted to ask you a framing question based on some of what Tony just said. So, I remember as a professor of constitutional law and reading these cases and watching the litigation and the legislation throughout the 80s and 90s and early 2000s, a lot of discussions about whether there were parallels to other rights movements in terms of the pace of change and the consistency of progress. And so what Tony just described is kind of a, not an arc, but more of a sawtooth wave, right? Up, down, but kind of an escalating direction of progress. So I have two questions for you. One, is that your sense? And then two, your insights with regard to whether there are any parallels with regard to the pace of change of other rights movements. So as this case law was evolving, comparisons were made, so it was 70 years from Plessy versus Ferguson to Loving. Should we expect 70 years for this kind of movement? And so what are your opinions on kind of the arc of progress? Was it uneven back and forth? But also just any thoughts about the pace of change and parallels to other rights movements?
Yeah. So, well, on the pace of change question, people will often say, this went so fast. Did you ever think it would go this fast? It seems like it was lightning speed, et cetera. And I feel like the president, and this is why we used it in the video, really captured this well. There's a reason people feel like justice came like a thunderbolt and boom. And yet, if you know the history, and if you pay attention to even your own history, as opposed to the feelings of this up and down and accelerating momentum at the end, you realize that thunderbolt really came after 40 years, and many of us lived through many of those battles. But it was always striking to me how people would forget the battles they themselves even lived through, let alone the things that happened before. I mean, I understand that not everybody remembers, because many people weren't alive, that the first cases were in the 70s. And as the video very quickly showed, there was huge moment, and then it was crushed, and then the 80s. And, so I understand that not everybody remembers that. But people sometimes would say to me that, who ever thought that it would begin with the Windsor case, right, or, that it would begin with California's Prop 8, and they forgot that they themselves lived through, well, Massachusetts, which was only a few years before, or that they themselves lived through Hawaii, which came right before. I mean, all of that was within 20 years, so it's not like it's ancient history, and yet emotionally it felt like it happened for people very fast, in part because for many people, there's a tendency to think of the world as beginning the day they woke up. And so whatever it was that brought them into it is what they think is the big thing or the moment it started, so on. But also because, as you rightly described, there were so many ups and downs and so on. So I think it's important to understand the pace was fast in the sense that the momentum accelerated, the strategy worked, it coalesced, and it happened, but all of that was 40 plus years in the making. And the other point I would make is that there was always a strategy. The strategy was that we were going to win by setting the stage for the Supreme Court to do the right thing. So although it is true that we saw this tremendous cascade over the last 2 years in which we won 70-some rulings as we got to the Supreme Court in the 2 years heading into the Supreme Court, that's a lot of change and a lot of progress and a lot of momentum, and everybody in the country felt it, whether they liked it or not. And by then, most people liked it, but there was certainly a substantial minority who didn't like it, but everybody could feel the momentum. It wasn't a shock when the Supreme Court ruled as it did, because everybody could feel like we were ready, right? But that also was always part of the idea. The idea was that once we had built a critical mass of states and a critical mass of support, and use this federal discrimination also as a way of reframing the conversation, that those would come together in a way that would set the stage for us to win in the Supreme Court. And the strategy said that until we had done that, we wouldn't be able to win in the Supreme Court, which is why we didn't win in 2013 what we won in 2015, even though some were in a rush to get there. But you needed to build this critical mass of states and this critical mass of support. And what people saw, whether they recognized it or not, was winning in Iowa, winning in New York, winning in DC, was what was building that critical mass that allowed eventually the door to open and everything to spill through in this cascade of the final cases. So that, I hope, gives a richer understanding of how you could experience this as a quick pace of change, and yet at the same time understand that it wasn't quick, and it wasn't magic, and it didn't happen just because of a court case, or one battle, or one victory, or one defeat. It took all these elements coming together, and that's the central social change lesson of this campaign that people need to understand. No one person, no one battle, no one case, no one state, no one decade is what won. It took all of that coming together, following a strategy, whether people knew they were following a strategy or not, to make it happen. And in terms of other movements, I would say that although the pace of change, I mean, even if you talk about 4 decades or 5 decades, which kind of in your social life is a long period of time, in historical time, that's not that long. And when you look at struggles for racial equality and struggles for women's empowerment, those very similar struggles have, of course, been going on for much longer. So in that sense, our movement's pace has been quicker and dramatic, in part because it has built on some of that progress, some of that momentum, and some of the lessons. But if you then step back from the pace and look at the elements of change, the fault lines, the difficulties, the challenges, the debates over whether it should be federal or state, should it be litigation or legislation, those are very similar across movements. And you can see the same arguments, the same debates. It's like they went to the same meetings in the women's movement, or in the African American civil rights movement, or in the suffrage movement in the early 1900s, or in the earlier struggles over African American suffrage in the 1800s. You could see the same arguments playing out over tactics and strategies and elements. But I would say our pace, though not as quick as people think, has been able to go quicker. And I think there are reasons for that we can also talk about.
Sure. So you picked up on what was going to be my next question. This one is for both of you, and I'll start with Tony. And then after this question, I want to talk about Obergefell a little bit more specifically. So the basic question is why? What accounts for the success? I've heard you describe the strategies. I've read the case law. I am by inclination pessimistic, more so now that I'm a dean. I won't explain that comment. But it struck me as by no means certain, watching from the outside, that this campaign was going to be successful at the Supreme Court. And so why? And we'll talk about the doctrine in a moment in the case and the equal protection and due process aspects at least a little bit. But why do you think this actually ended up succeeding and culminating in the Obergefell case? Because I don't think it was a certain outcome.
I didn't see it as a certain outcome either. I mean, I was a bit worried before the case actually came down as to the why. It's really, I mean, I think it's hard to explain. I mean, in the sense of, I mean, clearly, you know, you see, you know, some of the judges were on the side of same-sex marriage all along. And then some of them clearly were not. You basically have a swing vote who had written all of the favorable decisions in the past, so you'd hope that he would go there. But I mean, it was, I'm sure it was not easy on his part either, because it was kind of pulling at 2 different things that he cares about, you know, civil rights and also states' rights. So.
Well, I think when you ask the question, you also have to think about where are you looking for the answer. So, first of all, nothing is inevitable. I don't think it was a guarantee we were going to win. I wouldn't say that we could just sit back and assume we were on a glide path forever. And to the contrary, we worked every day right up to literally the moment we finally got it on our devices to do everything we could to implement the strategy of making America ready, of showing that America was ready, of underscoring the urgency, of continuing to build that support and show the court that they could and needed to do it. We didn't take anything for granted, so nothing was a given and so on. But even when you began answering the question, both of you really immediately went to the court where you were looking for the answer. And to me, the answer was never only in the court. The court was going to be the vehicle by which we achieved the fulfillment of the strategy. And what was going to get the win was, of course, good legal argument, good scholarship, good briefing, good stories, and the right justices, which is not totally in anybody's control, but you have to have that, and if you don't have it, you're not going to win that day. But what was going to enable us to win was not just the court and not just the legal doctrine and whether it was going to be easy or hard for Kennedy to write this way or that way. That was the end of the work. What was going to get us there was everything I described earlier, building that critical mass of skills, building the critical mass of support, showing the court they could do this, showing the court they needed to do this, making the court understand that if they didn't do this, history was going to look at them in the way we look at Roger Taney and others who wrote terrible decisions, the justices who wrote Plessy and so on. So, does that guarantee a win? No, nothing guarantees anything, but that's how you win. And when you think of it that way, that's where you can see that through ups and downs and stumbles and successes and trial and error and many failures and many mistakes, we did do a lot of things right that enabled this win to happen. It didn't happen just because of reading the brief and saying, well, that is a better argument. That was the part that, if that was all it took, we would have been done 40 years ago.
Yeah. So I want to focus in on the case a little bit itself. Since it's just us here, I'm going to have a cough drop. Sure. Don't mind me. Tony, what exactly was the constitutional basis for the decision in Obergefell? Are we doing equal protection? Are we doing substantive due process? Is it a blend of the two? Is it social libertarianism that's driving it? Is it the egalitarian strain in constitutional law? What exactly is going on as a matter of the legal doctrine in the case?
I mean, as a matter of the legal doctrine, I don't think anybody really knows what exactly, because they talk about equal protection, they talk about due process, but that's one of the complaints that the dissenters have about them, is that it's not really entirely clear exactly what they're doing. From the perspective of trying to win marriage equality, it doesn't really matter so much whether they use one theory or another. It matters what you get. Where it matters is in going forward, for future battles. What kind of clarity they give, so that way you can use the precedent later on in other battles. But I think it's contested. You could probably ask different people, and they'll give you different answers as to what really the theory was of the case.
So here's the answer I think we should be giving, because I think this is what's there. This decision is an extremely powerful decision that draws on what I think of as the double helix of constitutional power when it comes to civil rights, due process and equal protection, substantive freedom and the guarantee of equality. I think too much of academic commentary and too much of even some advocates' contrarian nature always invites them to try to pick those things apart. And I think what Justice Kennedy has now shown us in 4 major decisions over the last 20 years, including now the marriage decision, is that these two things are not opposite, and academics are wrong to keep saying, is it this or is it that? And instead should see them as combined together, because that's how the denial affects people. It denies both their freedom and their equality. And therefore, we ought to be teaching, and we ought to be advocating, and we ought to be litigating in fulfillment of what the court has done, which is to say these two things go together. The denial of marriage was both a denial of freedom, the freedom to marry, and of equality, equal dignity and equal treatment under the law. And the Constitution is offended in both ways, and both of those things together required ending this discrimination with regard to marriage, and both of them together send a signal to other courts, which is why it's important how we talk about this and how we teach, as Tony said, that the day of the gay exception, the day of taking gay people out of whatever it is is over. The Constitution does not allow that as a matter of substantive dignity and the ability to participate, and as equal treatment under the law. And what offends some of those who want to attack it is that Justice Kennedy didn't use some of the magic words that in my day we were taught in law school, but that the court has not used for decades. And I feel like it's important for academics and it's important for us as advocates to stop imagining that it needs to be the way we thought it was going to be based on what we learned 40 years ago, and instead actually look at what the court has done over the last 20 years, which is that even when they don't use a magic term now, like suspect class, or the tiers of equal protection analysis, or heightened scrutiny, this is heightened scrutiny. This is what it looks like, and it did the trick, and it's done the trick now in 4 major gay rights cases over the last 20 years. What more do you need? So that's how I would talk about it, and that's how I would teach it, and that's how I believe we should use it. And as far as the dissent goes, I think the dissent has no standing, the 4 justices who wrote in dissent, to critique this court for unclarity, given that none of the dissenters, not one, in any way substantively engaged with any of the real arguments put forward by these couples who were being denied the freedom to marry, didn't talk about the harms. All they did was fulminate against the majority without doing the analysis to show why they ought to be right and that the court got it wrong. They blasted the court for getting it wrong, but they didn't explain in any way how they got it wrong. So they have no standing to argue that somehow the majority is not clear.
Sure. So let me geek out as a constitutional law professor here real briefly, 2 things. First, that's too complicated. I got to teach first-year constitutional law. You tell me what level of scrutiny applies, I run you through the analysis. You tell me it's substantive due process, I do something else. So your point is well taken, right? That the court may be signaling that kind of the rigidified constitutional separation between substantive due process and equal protection is not always written in stone. Second, and more seriously though, so that's fair, but then I think about this. I think about the next case or the next movement, looking down the road. And you've read the oral arguments, and you've read the oral arguments in these cases, and to the extent that there's not doctrinal clarity on what the decision is grounded in, doesn't it leave it open, A, to future reversal and attack on kind of very technical grounds? The court did not apply the right level of scrutiny, ergo, the decision is overruled. Or when you're thinking about extending to a new battle, either for this community or other communities, you get into things like in the oral arguments in these cases whereby the court says, look, if we're doing equal protection, then the touchstone is whether this group is a discrete and insular minority, and it's not. It's winning at the legislative level, spoke Justice Scalia. How can they be a discrete and insular minority that's entitled to special constitutional solicitude? And if they're not entitled to special constitutional solicitude, the democratic process, not the judiciary, should rule. So doesn't the lack of doctrinal clarity create some vulnerability?
Well, what I would say is it's the job of advocates and the job of academics to provide clarity and to make strong, clear arguments that can be invoked to refute disingenuous or sometimes troubled questions such as the ones you're having posed. But that's different from saying that because it didn't look like the way we thought it was supposed to look based on what we had learned 20 or 30 or 40 years ago, that somehow it's a complete muddle and you can't make any sense of it. I think when you read these decisions of Justice Kennedy in the last 4 major cases over 20 years, it's very clear that what he's saying is that when there's an unusual kind of exclusion, an unusual kind of suspicion, when it falls on a group that does have a history of discrimination, there's smoke there, and therefore we need to look for the fire, and not just rubber stamp it away and say, well, but they didn't get this formal designation over here or there, so we can just do whatever we want, which is what the opponents would be saying on the bench and in the courts for the last 20 or 30 years, etc. They had no problem just basically doing no analysis because they felt the only analysis was, is there a magic word attached to this group? No, there isn't. Well, then they're out. And they would even deny the magic word to the group of gay people based on a case that had nothing to do with magic wordishness, the Hardwood case, the so-called sodomy case, which was about arresting people in their bedroom for private consensual sex. And because the court got that wrong in 1986, a whole bunch of courts then felt compelled to say, well, then there's no equal protection problem at all with discriminating against this group in any way whatsoever. So, the lack of analysis and lack of clarity seems to work perfectly fine when it's discriminating. Why can't we take that and then make it a little clearer and give it a little strength in order to advance the work, as Justice Kennedy has now done in 4 cases? So that would be my argument on doctrine. And I also, and this may be heresy in a law school, but as I said, it was something that came to me as a law student. It's something I believed, which is, you can talk we can talk all we want about the law and about doctrine and about clarity and all these things. And of course that's important. That's the work we need to do as lawyers. It's part of what we bring to the larger work of social change. But if that's what it took to achieve social change, as I said earlier, we would have been done 40 years ago. We would have ended race discrimination in the law. We would have ended sex discrimination in the law. And yet we continue to have these battles because, as we all know, actually, the law and doctrine and clarity and all these kinds of things with regard to argument aren't the sum total of how you achieve social change. They aren't the sum total of how you fulfill the Constitution's command. So I feel like we need to get in those of us who have a vision of the country that we're working for and fighting for, and a vision of the Constitution that we want to uphold, shouldn't be spending our time second-guessing and undermining and nitpicking under the banner of doctrine. We should be bringing our part to the persuasion and the clarity and the values and the compelling stories that actually do make change within the court of public opinion, but also actually within the court of law. And where you began, Dean, by actually, half-jokingly talking about what will explain it to first-year law students, I actually think that's a really great place to begin, because it's before people have gotten caught up in a specific, narrow, particular kind of analysis. What is the broader kind of analysis and broader engagement with real values, real stories, real compelling arguments that then are reflected in doctrine? That actually is, I think, how you win a case and how you win a cause.
Let me turn this to Tony for his thoughts on that question, but I can't help but note, if you saw me smiling during your remarks, it sounds like you're channeling another native Pittsburgh distinguished scholar, Derek Bell, an alumnus of this law school, and his focus on critical realism in the law, and not believing that justice is always best achieved in the confines of the case.
Right.
I mean, I guess the only thing that I would kind of add to that is just, I mean, and I perfectly get what you're saying about having it make sense and everything like that, but when you read all of the lower court decisions, I mean, you think about how the Supreme Court sets the stage for all the lower courts, and the lower courts spend all of their time doing all of exactly these things, trying to figure out, based on, the framework that we've had for years and years and years, how do you deal with this case and how do you do it? On a certain level, if the Supreme Court's moving towards just saying, well, if it's a group that's, unusually singled out and whatever, then this is what you should be doing. It's like, well, okay, then you just say that that's what you're doing, that we're getting rid of these other things, so that way people don't spend lots of time arguing about, are you an insular minority? Does political power matter? When does it matter? How do you, square it with people who are still suspect classes who have a lot more power? And so part of it is just being honest about what you're doing. I mean, if that's what they're really doing, then you say, this is what we're doing because we set the tone, all the courts below us have to apply what we say. And if they think they're still working within a framework that they're just ignoring, rather than just coming out and saying they're not using anymore, I mean, it's more intellectually honest, I think, to just say what you're doing rather than just ignoring what's inconvenient. Because part of the problem with that, I think, too, is it feeds into the whole kind of perception of the Supreme Court as being highly political and not really about applying the law. That it's just about, can you get 5 people who are on your side? It doesn't really matter what the legal arguments are or what the law says. They're just going to decide what you want, which is, kind of become more of a meme, in the past 10, 15, 20 years. And to the extent that they're not actually being honest about what they're doing, you're just feeding that meme, that it just looks like it's, whatever they want, and they're manipulating things.
Well, I do agree with you that honesty is good and clarity is good. And so, for example, we talked openly about what our strategy was. It was never a secret strategy to win the Freedom Square. We had it on our website. We wanted people to know how we believed this change was going to happen. And as I said, we always said it was going to happen with the right litigation and smart litigation vehicles, but also the need to build this critical mass of states and this critical mass of support that would create the climate that would encourage the court to be able to do the right thing. So I agree with you about honesty, but I also think that it's actually not that hard to see what is at stake here. And the fact that it's so clear that people are being denied something really, really important that registers in the Constitution's command of freedom and equality can be very visibly seen by the fact that none of the dissents made any real effort to argue why the court got it wrong. They just said the court shouldn't do it. But they didn't say, why is it wrong? Why is it okay to deny gay couples? And part of the reason they couldn't go there is because by the time we reached the Supreme Court, after decades of litigation as well as public debate and deliberation, we had exposed every argument as false and untrue. And when the state stood in the Supreme Court in April arguing in the last effort, they made arguments that were ludicrous and that even the dissent could not take seriously as reasons for denying gay people the freedom to marry. The idea that if we allow, that part of the reason we can't allow gay people to marry is because we need to have marriage as something that's so good that only heterosexuals can do it, because heterosexuals need it and gay people don't, because heterosexuals are the ones who will have accidental procreation. And so we need to force them into marriage. I mean, you laugh, but this was the argument. This was the last thing they were left doubling down on in the court. And even those who are not on our side were, come on. So, and which is why they didn't have anything to write in the dissent. And as I mentioned earlier, in the 2 years leading up to the Supreme Court as the culmination of this strategy, we won 70-some cases, and as you rightly said, Tony, we lost only a handful, I think 3 or 4 cases in that 2-year period, won 70 in federal and state court, appellate and trial court, judges appointed by Democrats as well as judges appointed by Republicans. All were looking at the arguments that were being made and looking at the evidence and finally giving it a real hearing, which the courts in the 70s and 80s were unwilling to do, and saying there's no good reason for denying this. So when it gets to the Supreme Court, it's not that hard for the court to get it right. And in those 70 cases that we won leading up to the Supreme Court victory, my favorite passage came in the case we won in Utah, in which we brought the freedom to marry to that reddest of red states. And the judge in Utah, a Republican appointee, by the way, wrote, and this is my favorite passage of all the court cases, he said, "It's not the Constitution that has changed, it's our knowledge of what it means to be lesbian and gay." And in that passage, I think he really captured what is the real heart of the strategy and of how this social change occurs that is then reflected in law, which is that the Constitution arguments were not that hard here. I mean, a 26-year-old wrote them in law school back in the 80s. They weren't that difficult. It wasn't that difficult to see why there was an equal protection denial, even under those classes and so on that we were learning in the 80s that the court barely has ever used since. It wasn't that hard to write the legal argument, but what was hard was getting the public and making decision makers, including judges, be willing to see how that command applied to gay people. And that was the real work of change.
So I want to ask 2 last questions. I think I still have enough time for this. The second question will be addressed primarily to our good friend, Representative Frankel, so I'll invite him up in just a moment. But I want to give the dissent its due. Okay, so I'll ask you to respond to this, and Tony, you can jump in if you want, by virtue of a slightly extended quote, if you'll bear with me, from Chief Justice Roberts' dissent. "Although the policy arguments for extending marriage to same-sex couples may be compelling, the legal arguments for requiring such an extension are not. The fundamental right to marry does not include a right to make a state change its definition of marriage. The people of a state are free to expand marriage to include same-sex couples or to retain the historic designation. For those who believe in a government of laws, not of men, the majority's approach today is deeply disheartening. Supporters of same-sex marriage have achieved considerable success persuading their fellow citizens through the democratic process to adopt their view. That ends today. 5 lawyers have closed the debate and enacted their own vision of marriage as a matter of constitutional law." Your response?
Yeah, well, first of all, did you hear any argument in there as to why the gay people should, under the law, be denied the freedom to marry? What is the basis on which the state may deny something as precious and important as the freedom to marry and equal protection of the law? No, it's the same kind of fiat statement that he's accusing the majority of making, a majority that he, I think, actually despicably characterizes as 5 lawyers, as opposed to, we also call them justices, and they sit on the same court he does. And I think that, in the name of supposedly legitimating our Constitution and the constitutional process, he actually did more to delegitimate the Constitution in that passage than I think a justice has done in a very long time. I thought that passage and that dissent by Chief Justice Roberts were despicable. You know, the court gets things wrong. Nobody has to tell me that. I spent most of my life arguing the Supreme Court is wrong until we finally got it right. The Supreme Court gets things wrong, but that's different from arguing that the Supreme Court is illegitimate or has no power. And in another passage you could have quoted, the more colorful passage, he eulogized the Aztecs as some great source of constitutional wisdom because they had some vision of marriage, and then said, who do we think we are? Well, we think, he said basically the court invalidates the marriage laws of more than half the states and orders the transformation of a social injustice that is a social institution that has formed the basis of human society for millennia for the Kalahari Bushmen and the Han Chinese, the Carthaginians and the Aztecs. Just who do we think we are? Well, I know who I think he is. I mean, I think he's a justice of the Supreme Court who, unlike the Aztecs, the Han Chinese, the Carthaginians, and the Kalahari Bushmen, have a constitution that guarantees all of us certain inalienable, et cetera, et cetera. So I find the passage you read actually the perfect proof of what I'm talking about. They have no moral leg to stand on in this critique because even less than the majority, he did not engage in any of the arguments over the evidence and briefing that were put before the court, and by the way, again, not just put before the Supreme Court, put before 70 courts, judges all across the country who sifted through evidence and arguments and applied the command of the Constitution with this doctrinal analysis or that doctrinal, and some of them got very doctrinal, and others were more looking at the core command, and all of them, except for 3, got it right. Where is that in the opinion, in the dissent? So I actually think what Chief Justice Roberts and the dissents did was expose how they had nothing there, and their position was the one that, if embraced, would have been the illegitimate one, because it would have been, again, a fiat, a denial, a refusal to apply the command of the Constitution. The whole reason we have a Constitution and courts is that not everything should be put up to a vote. And yes, we are a democratic republic, but we are a constitutional democratic republic in which we do not believe everything should be put up to a vote, and the majority can simply decide things, and people have to petition and scrap and scramble and spend decades fighting for what some of them never lived to see. That's not our system. Our system is, and we celebrate it on Constitution Day, a system in which we all have the guarantee of freedom and the guarantee of equality. And it's the court's job to step in when the legislatures deny that or when the majority denies that.
Listen, next time we have you, I want you to tell us what you really think. Because I can tell you're holding back, Evan. Let me, Tony, with apologies, I'm sure there will be an opportunity for further dialogue when we get to the Q&A. I do want to leave time for that, but my last question, which I do want to invite Representative Frankel to address, at least here at the state level, is what's next, right? With this right at least secured for now, nothing is secure forever, but secured for now. What's next? What are the next frontiers? What are the next battles? And so, Representative Frankel, if you'll give us the benefit of your thoughts, I'd greatly appreciate it.
Well, thank you. I just want to thank both Tony and Chip for inviting me here today, and I am really honored to be here with Evan Wolfson, who has certainly become one of the giants of the civil rights movement, the modern civil rights movement of our generation in this country, and congratulate him for the extraordinary work that he did to get marriage equality. And I think it's a lesson, again, to the process, to listen to his more than 3 decades of work in order to achieve the transformation, and the transformation really coming through the hearts and minds of people at the grassroots level was really an extraordinary work, and then taking it to the next level legally. Let me offer a disclaimer also. I'm not a lawyer, so I don't know if this discounts your CLE credits for the day, but I just will talk to you a little bit about what I see as the next steps, and really the next steps are really the old steps. I mean, quite frankly, we're talking in Harrisburg now. We just introduced last week for the 5th or 6th session in a row what had been known as House Bill 300, Non-Discrimination Act for Pennsylvania, we've now rebranded as the Pennsylvania Fairness Act. It basically would be an amendment to the Pennsylvania Human Relations Act that provides civil rights protections to a number of different classes of people based on gender, on race, on religion, on disability, on age, to include protected classes for people on the basis of their sexual orientation, gender identity, or expression. You would think, as as Dean, somebody said earlier, that we would have had this done. Most people say you can fire somebody because they're gay or lesbian or transgender. Most people in this state don't believe that. But the fact is, it is the last vestige of legal discrimination in this country, and it is in most of this country, not in all the country. And it's still legal in Pennsylvania, with the exception of the fact that as we've been trying to get this legislation passed year after year, session after session, while the legislature has failed to act, municipalities, local jurisdictions across Pennsylvania have moved forward on this issue. So we've seen 34 local jurisdictions across Pennsylvania adopt civil rights protections, non-discrimination statutes at the local level, including the city of Pittsburgh, Allegheny County, and Philadelphia, as well as all the third-class cities in Pennsylvania who have adopted non-discrimination. It begs the question, ultimately, that when you go from one jurisdiction to another in Pennsylvania, you know, if you live in Allegheny County and work in Butler County, you can be fired. You know, you can get married on Sunday, walk into your office on Monday, place a photograph of you and your spouse, same-sex spouse, on your desk, have your supervisor or boss walk by and disapprove of it and say, you're out of here. And that happens. So we believe that the next thing that we need to get done here in Pennsylvania that is not obviously taken care of by the Supreme Court decision on marriage equality is equal rights for the LGBT community. That would be really the capstone, I think, to make sure that we have equal standing for all Pennsylvanians regardless of their sexual orientation, gender identity, and expression. It is really a blemish on the state that we are the only Northeast state that doesn't have a statewide non-discrimination law. But progress has been made. I mean, over the years, we have made significant progress, at least in terms of the hearts and minds of Pennsylvanians and the hearts and minds of legislators. So what we see now, we have polling that we've done probably every 2 years that shows 72% of Pennsylvanians support non-discrimination. And it's in every single region. You know, over 68% in every single region of the state when you break it down. We've seen changes in the hearts and minds of legislators. The bills that we've introduced here, both in the Senate and the House within the last 2 weeks, have about 90 co-sponsors in the House version of the bill, including 14 Republicans. In the Senate, we have 25 of 50 state senators supporting the bill, including 6 Republican members. So the ingredients are there. We have some obstacles, as many of you know, legislatively. We have to get it through committee. We need Republican leadership to embrace these bills. That hasn't happened yet. Those hearts and minds still need to be encouraged. We see some glimmers of hope. And as a matter of fact, we've actually injected, I know many of you probably are aware that we have still to have a Pennsylvania budget approved, but we've tried to include this as part of the budget negotiation as one of the issues that we want, certainly my caucus, the Democratic caucus in the House and the Senate, would like to see addressed in conjunction with the state budget. We've tried to orchestrate this in a way that I think a lot of people understand, and we've had the business community really step up. We have the Pittsburgh Chamber of Commerce, the Philadelphia Chamber of Commerce. We have businesses across the state who've embraced this. You saw what happened in Indiana and Arkansas, the outcry on their religious freedom legislation. The business community, I think, put the fear of God into a lot of people about states that dared to embrace discrimination. But the fact of the matter is, we have it here in Pennsylvania. We didn't have anything to make it happen, but we do de facto have the ability to discriminate. So we're working hard to change that. I'm optimistic. I do think, I don't like to use the word inevitable, it is inevitable that someday we will get there. I'm hoping it will be in this session of the legislature. I'm hoping that Pennsylvania won't be the last state to the table to eliminate this glaring and really embarrassing and omission in terms of civil rights. So that's where we stand. Again, I appreciate the opportunity to be here, and again with such a distinguished panel and with such a distinguished Pittsburgher as Evan Wolfson. And again, congratulations to all the work you've done. Thank you.
Thank you. Thank you so much. So I've asked Representative Frankel to come to the table in case people have questions for him as well as our other two panelists. I do want to make sure I leave enough time to address some of the audience questions. Before I do so, though, I made a terrible omission in my opening remarks. I forgot to thank our co-sponsors. The ACLU was a generous co-sponsor, as was Pitt's Department of Gender, Sexuality, and Women's Studies, and Pitt Law's own Outlaw, our student organization devoted to working on these issues. So I hope you'll join me in thanking our co-sponsors. With that, if you have questions for the group, if you could pass them forward to Associate Dean Hammoudi, I would appreciate that. In the meantime, I will start with the first question. I believe this is likely directed in the first instance to Tony and perhaps secondarily to Evan. So the question is, since the Supreme Court essentially made the LGBT community into a protected class in the Obergefell case, what are your predictions on the issue of backlash? We're starting to see some of those play out, obviously, very contemporaneously. But do you think that we are entering a phase of massive resistance? Are we going to have George Wallace's in the courthouse door on this issue? Or is this kind of a natural flare-up in the wake of a still contentious matter of social policy?
I mean, it's hard to predict how much backlash. I mean, there's some backlash, as the dean said already. You know, you see Kim Davis in Kentucky, and you see other things. I mean, there's little things that people don't always realize. I mean, so one of the things that I focus on in my writing is not just tax, but also family-type issues. So when you're talking about family formations, you know, you're talking about lesbian couples sometimes using artificial insemination to procreate. Some states have been resisting, you know, having the non-biological mother listed on the birth certificate, even though there's a presumption of parentage that usually when a different sex couple uses artificial insemination, they'll assume that the husband is the father, whether he is or not. And those are usually written in a gendered fashion, and some states have been resisting that, and lesbian couples have been having to go to court to get that right, to get themselves named on the birth certificate. So, I mean, there's going to be, I think, backlash at different levels. I mean, part of the backlash is kind of the push for religious accommodations. I think that's going to be the biggest, you know, backlash of people trying to pass laws that allow people to kind of opt out, you know, opt out of non-discrimination. I mean, that'll probably be one of the, I would imagine, the bigger fights. I was looking for you over there. I forgot you're sitting next to me. Probably one of the bigger fights will be, you know, about how much religious accommodation in the Pennsylvania Fairness Act. I think that's where a lot of the trouble is going to be in the coming years.
Evan, anything you'd like to add?
Sure. So In my book, Why Marriage Matters, I quote a speech by Martin Luther King that he gave in 1966 at Howard University. And in it, he essentially said, I hate the word backlash. Backlash falsely conveys the idea that everything was going just fine, and then some of us who believed in equality or civil rights went too far or asked for too much or went too fast, and there was a reaction. That's not at all, Dr. King said, what's happening. What's happening is there is and always has been a struggle between contesting views, contesting visions for our country and our society. And the way I used to summarize that when I was giving speech after speech after speech through those 80s and 90s and 2000s as we were building was I would say to people, their backlash began before we even lashed. Their discrimination was there. This effort to deny and to prevent was there. We're trying to change that because we believe in inclusion and equality and freedom for all. So what we're seeing now, by no stretch of the imagination, should be understood as backlash, which is sort of a disempowering term that tells you that somehow if you just asked for less or went slower or found some kind of middle ground in discrimination, it would be okay. That's not true. What's true is we are working hard to fulfill the Constitution and to provide equality under the law and equal dignity and treatment for everybody. And there are those who don't like that. And when they fail to block civil rights advances, they then try to subvert them as their next tactic, often cloaked in the misleading banner of so-called religious freedom. And the religious freedom excuse to discriminate is nothing new. It's not something that's starting now. It's not something that gays somehow unwittingly provoked. This has been a tactic of civil rights subversion going back to the 50s and the 60s and the 70s, and as we began fighting for women's emancipation and equality, it was used as a tactic to say, well, we shouldn't have to treat women this way because we believe the wife should submit, et cetera, et cetera. This is nothing new, and it's not backlash. It is a struggle. It's the same struggle under a different banner. And the other piece that I would add is that actually what we're seeing across the country, I think not really that surprising, is there hasn't even been much of that. There hasn't been much, quote, resistance or, quote, backlash. There have been a few isolated instances of grandstanding and acting out. Freedom to Marry put out a graphic the other day that 99.4% of the counties in this country are issuing marriage licenses without problem to all couples who deserve those licenses. What we're seeing is that in a very small number of counties, particularly a few in Alabama, which has its legal structure, and now one sort of well-attended one in Kentucky, where, by the way, the licenses are now issuing, there's been a little bit of acting out. Well, you know, it's a big country. It's been 2 months since the court has ruled. That's not backlash. That's not even really massive resistance. It's isolated instances of acting out and grandstanding that needs to be understood for what it is, needs to be dealt with and taken seriously, but will be, and will be resolved because actually the vast majority of the American people support the freedom to marry, and an even larger majority, including those who don't fully support it, understand that we have to follow the law. But I will say, to your point, that this tactic of claiming religious freedom as an excuse to discriminate is a familiar tactic. And it is one that is being used now, yet again, by forces who not only oppose gay people's equality, but oppose women's access to reproductive freedom and to health care, and who actually, some would argue for all kinds of permissions to do anything they don't want to have in law, they want to be excused from. So, you know, you have the likes of Mike Huckabee and others promoting this agenda and using this familiar tactic. So it is an important battleground that we have to fight about, but that's not about gay people per se, and it's not about marriage per se. It's the larger contours of civil rights struggle in America, and we have to keep working. Winning a court case, winning in the law, winning the hearts and minds is never enough. You always have to keep working and keep fighting.
Thank you. A couple of brief comments. Just so you're aware, we're obviously not going to have the opportunity to get to all of the audience questions, but hopefully you'll have the opportunity for dialogue upstairs with our panelists during the reception. Secondly, the Associate Dean Hammoudi did not specify legibility as a condition for me reading your question, so some of them I can't read. But what I can read is for Representative Frankel. Fairly straightforward question. What can we, as citizens of Pennsylvania, do to help get this legislation passed?
Well, I mean, it's what Evan Wolfson was doing for 30 years. It's effective advocacy. It's talking to your elected representatives, and particularly for members of the LGBT community. I mean, one of the most dramatic things that I saw in terms of transformation of some of my colleagues' feelings is we had in the last session of the legislature 2 openly gay members, 1 Republican and 1 Democrat. And it's very difficult, I think, when you're sitting across the table or sitting next to the person on the floor to be so sure of your opinions with respect to your desire to continue to discriminate against that person. And those 2 members were very outspoken, and I think would help with the transformation. I've had, over the years, colleagues of mine say they had never met a LGBT constituent, which is so hard to believe, let alone not having an LGBT member somewhere in your family or among your friends. They probably, but it's incumbent, I think, on people in this community to talk to their legislators. So it's the allies of the LGBT community and it's members of the LGBT community. Now, I will say this. There are enormous resources that have been brought to bear for the first time to this battle in Pennsylvania. We have worked very closely with our allies, the ACLU, the Women's Law Project, the Human Rights Campaign, the transgender equality movement out of Washington, D.C., are all engaged in Pennsylvania. And it's not just their voices and their letters, but it's actual money on the ground. We have folks that are working with Equality Pennsylvania, through Equality Pennsylvania. We have canvassers, we have people on the phones working the constituencies of members to help make this happen. So I would say that members here, people here, your friends and family, if you have an interest in this, if you have an interest in bringing fairness and equality finally to this state without respect to what jurisdiction you're in, go see your legislator.
Thank you. I want to give Evan the opportunity to have the last word. And if you could share with us something that I'm just personally curious about on the theme of what's next. What's next for you? As I've heard you say repeatedly, you put yourself out of business, right? And so where do you see your efforts and energy going, as well as just closing remarks around the theme for today's Constitution Day event?
Sure. Well, thank you. So Freedom to Marry was the campaign that was built to drive the strategy that would enable this movement over many decades of many pieces and parts and litigation and legislation and public education to bring all of that together in furtherance of a shared strategy toward a goal. And this campaign has now achieved its goal. So the work of the Freedom to Marry campaign is over, and we are now beginning a very careful, strategic wind down, and will close in a matter of months. But as we've heard, the work of this movement is far from over. And there's an enormous amount of work still to do, including, most centrally, I believe, working to pass a federal civil rights law, to pass important state and local legislation across the country that would prohibit discrimination against people based on their sexual orientation and gender identity in employment, in housing, in public accommodations like stores and theaters, what Representative Frankel's bill does. And I want to give a real thank you to Representative Frankel for carrying this banner for so many decades now and years. And I really think the time is now. We can harness the power of this marriage conversation and the hearts and minds it has moved and continues to move. and the weddings that people will continue to see, and the family members they'll hear from with greater visibility across Pennsylvania as across the country, we can harness all of that continuing momentum to the legal and political work of passing these bills and getting the right court decisions to end discrimination. And that's the goal that we should all be working on. And Representative Frankel mentioned some of the groups that are working here, the ACLU and others, that people should sign up with and support and find out the action steps that they can take to really make a difference. There's a new campaign that's been launched as a joint campaign called, I believe, Pennsylvania Competes, that is part of this larger next campaign that many of us are building in the country on the Freedom to Marry model, to pull together all these different pieces and drive it toward this next goal of passing and securing non-discrimination protections. Nationally, it's called Freedom for All Americans, and it's a Freedom to Marry style organization aimed at bringing together the work of many. And in Pennsylvania, it's called Pennsylvania Competes. And so people can Google that and sign up and really get engaged. And let's get this done in Pennsylvania, as was said earlier, rather than later. We deserve that here in Pennsylvania. And as far as me personally, I don't know what I'm doing next. I haven't decided. I've been, as you know, working on this for 32 years, and I just need a little bit of time and opportunity to figure out who am I when I'm not Mr. Marriage, and who am I, and how can I best contribute and help. So I feel completely energized, excited. I want to be part of the next work in our country, and not just on gay and transgender causes, but on so many of things that we need to get right in our country, that we could all work through a whole list of things that are really important. And I feel like I can have the opportunity now to be part of many things and figure out how to help, and then I'll know what the right path is. And so right now I'm still working on the wind down and sharing the lessons and cheerleading on the next big fight.
Sure. Thank you all so much. Will you all please join me in thanking all of our distinguished panelists. Just a wonderful, wonderful program. Thank you all so much for coming. I only have two brief words in closing. The first is, Evan, as you're figuring things out, if you get tired of New York and Columbia and various things happening here, I hear there's a nice house with a warm bed in Pittsburgh where we might be able to take advantage of some of your talents here at the law school. So I wanted to just say that publicly. Secondly, I do hope you'll all join us upstairs for the reception, both because we paid for it, so you should eat and drink it, but also because it is an opportunity to continue this very important conversation. Lastly, I did just want to mention, because this is being recorded on a point of personal privilege, I purposefully asked our babysitter to bring my kids to this event. They're going to get bashful now. Although they could have stayed at home with the babysitter until I got home, I thought it was important for them to be here for this, so that then when they're slightly older and they're looking back on the things that they're able to do because of the work of people like Tony and Representative Frankel and Evan, I want them to be able to remember this moment and understand that they were in the presence of people who made the world a better place. So thank you all for your time. I'll see you upstairs. Thank you guys so much. This was great. Thanks. No hands. You don't want